Not that I'm aware of.
All right, that's the best we can do then. You may call the first case.
Albert Fuqua versus the Robertson County Election Commission et al.
Good morning, Your Honors. Jim Roberts on behalf of the appellant. I would appreciate preserving 4 minutes of my time, please.
4 minutes.
Yes, sir.
All right, you may proceed.
Good morning, Your Honor. This is what I hope to be a relatively simple case, which is the statutory interpretation of Tennessee Code Annotated 2-5-101F. And that section of the code tells us who is not allowed to be a candidate. And that simply was what this court is being asked to interpret. The beauty of this case is that we know what it means to qualify. And when we look at the section F2, which is what the focus is of today, F2 prohibits a person, or says it is unlawful for a person to qualify as an independent candidate and as a primary candidate, that is like a Republican or Democrat candidate, for the same office in the same year. That's a simple prohibition. The trial court's interpretation of that statute and the interpretation of the Osment case would eviscerate that section. It would also eviscerate section F1, and it would also eviscerate section F3. So the trial court's interpretation pretty much flies in the face of what the court, or excuse me, what the legislature enacted. What had happened in this case, it's really pretty simple. A candidate wanting to game the system went to the election commission and got both a Republican primary ballot petition and an independent ballot petition on the same day at the same time, and got a number of people to sign them, and then selectively decided how she would feed those to the election commission. She started off by putting in as a Republican, later decided she didn't want to run as Republican, withdrew, came back, put it in on the same day, minutes later, decided she wanted to be an independent candidate. And I'll submit to you that that is expressly prohibited by section F2 because she has such qualified as both a Republican and as an independent. The problem I think the appellees have, and they did not address in their brief, I might note, is what is the definition of qualified? And we spent a good bit of time talking about what does it mean to qualify, because fortunately the legislature told us. And in section 101A, it says very clearly that to qualify, a candidate shall qualify by filing all nominating petitions, including any duplicates, by the deadlines set out in the schedule in this section. So we have a very clear section that says, here's what it means to qualify, here's how you qualify. So now a candidate knows what they need to do. But here are the people who are statutorily prohibited, or unlawful is the word, from running based on their qualifying. And Ms. Chowning, in this case, Your Honor, we submit, absolutely was an illegal candidate. And we call her that, not that she's a criminal or a terrible person, but that she did not qualify and she was acting unlawfully under the statute by attempting to be a candidate. There is no dispute that she did these things. And the problem with the appellee's argument, and I believe the trial court's order, is this suggestion that this doesn't mean what it says, that a candidate, any candidate, could go in and request nominating petitions for any number of, they could do a Democrat and a Republican and an independent and a Green Party and a Communist Party. They could take out any number of petitions and file those, qualify, and withdraw an unlimited number of times. That is, I submit to you, not what the legislature intended.
What's the effect of a withdrawal, though?
I'm sorry, Your Honor?
What's the effect of a withdrawal?
Well, the effect of the withdrawal is they are no longer a candidate. And clearly, they have a right to cease being a candidate. No one can be forced to be a candidate. The question is not, do they have a right to withdraw? The question is, what are the consequences? What are the consequences of qualifying and then withdrawing? And we saw that in the Osment case, in a very narrow, specific situation where he withdrew and then tried to undo his withdrawal. And rightly, the Supreme Court said, no, of course not. You can't undo a withdrawal, especially after the deadlines have passed. But once they withdraw, there's nothing that says they were never a candidate. There's nothing that says that they weren't qualified. There's certainly nothing in the statute that permits you to act contrary to what F2 specifically states. It says unlawful for a person to qualify. And there's no dispute. I don't believe they can argue that she did not qualify as a Republican. She did, withdrew, and then she qualified as an independent. And I would submit that this is very simple. That's expressly prohibited. She didn't run as a Republican, get defeated, and then try to run as an independent. That would have been excluded, illegal, under Section F3. I mean, if you go through these F sections, it's clearly the legislature saying, we want people to participate in the electoral process, but we're not going to let you game the system. You're not going to be able to play games and do things and jump around. We want election purity. And when you look at this case in the light of that, is what Ms. Chowling did an appropriate action? I don't mind her pulling the petitions. I don't mind her going out and get them signed. But she made a choice. Under the law, she made a choice to turn in that petition. And the legislature basically, in so many words, has said, when you make that choice, decide who you want to dance with, you have to stay with that entity for at least a year. You can't run as a different candidate for at least a year. That is the restriction.
Why is this matter not moot?
It shouldn't be moot for two reasons. One, this is a vital public interest because of always the very quick process between the election process.
Say that about any election, can't you?
Well, it's also under the public exception doctrine, the fact that it's something capable of being reproduced and occurring several times. In this particular case.
That's sort of an interesting argument in that if it's capable of happening so many times, and there's no case law on this.
Well, I'm sorry, say that again, Your Honor.
Well, if this had happened before, or if this was an issue that was capable of repetition and problematic, then it would seem logical that there would be some case law on this specific issue.
Well, absolutely, and then I think that's a testament to the fact how clearly this statute is written, and that no one has tried to do what Ms. Chowning has done. No.
Doesn't that argue against this not being moot?
Well, the problem is if this court gives its approval to this, if it in a ruling says it's okay for a person to pull as many nominating petitions at once, gather as many signatures as they want, and turn them in, and they could get more than one Republican. They could get 2 or 3 Republicans or 2 or 3 Democrats. You're putting a seal of approval on a strategy that candidates will use in the future, which has no benefit to the public at large.
I understand that argument, but I'm talking about the mootness issue now.
Well, it's the mootness. You know, I would ask this court, not only is it capable of repetition, but also the facts of this case is this lawsuit was timely filed, but as the court knows, one of the illegal candidate was a employee of the Chancery Court system. There were some issues there, whether it be appropriate for the chancellor in that jurisdiction to hear this case. We did not get a judge appointed till June 20th. We lost 45 days just trying to get an impartial judge. In these election contests, you're always dealing with people in the local governments, obviously. You're dealing with the local courts, which are elected officials. There's always that risk that there's going to be some sort of appearance of impropriety. And I would submit in a judicially related election, there's almost more important that this court not say this issue is moot, that the court say, no, we need to address the qualifications aspects of the statute because we need to have clear rules of what is appropriate and what is not appropriate. We had to wait till June 20th. By June 20th, as you notice in the brief, the mail-in ballots, the overseas ballots were already sent out. So by the time we got a judge, Mr. Fuqua got a judge, they'd already started the election process. You go back to how long it takes to get those ballots approved. They have to be approved by the Tennessee Election Commission. You almost have almost no time to file a lawsuit, have adjudication, get a fair judge, and appeal. There's almost no way this case would ever get before this court. And, Your Honor, I would suggest that may be why this court hasn't seen many cases like this. We believe, Your Honor, that this statute is very clear that when it says shall qualify, that it's this court's duty to look at a statute that's clear and say, what did the legislature intend? It's the very first paragraph of the statute. It says, here's how we're going to define shall qualify. And then it says, here's what you can't do. Here's how you cannot qualify. I don't know how we could ever expedite this process any faster than what has been done in this case. And so the fear here is part of the mootness doctrine, Your Honor, to end it with, is that the Election Commission didn't know what to do. Now, I was not at that meeting, but I read the minutes. They didn't, their action was by inaction. They refused to do anything, but they admittedly did so in part based on an email that they received from the State Election Commission. I don't believe that the State Election Commission, while it's certainly a good organization, should be acting in a judicial capacity, and essentially was giving legal advice, interpreting the Osment case.
They're not parties.
And they're not a party. That's right. But
I mean, you had them as a party, but you let them out, didn't you?
I did, Your Honor. They were not, I don't believe that they were a necessary party under these circumstances, and we're not challenging their actions. We're challenging the local election commission's actions. But there still is a reliance there of the State Election Commission acting almost as a court, giving legal advice, which they can do to an extent. I understand that. But also, they're going to advise other election commissions that it is okay, and that's what was at stake here. Is it okay for a person to go down and get as many petitions as they want, gather signatures, turn them in, withdraw, turn them in, withdraw, unlimited? There's nothing, there can be no constraints under the trial court's ruling and the appellee's arguments. It has to be unlimited. You can either do it once, which we submit the statute says, or you can do it an unlimited number of times. And does that lead to election purity? The Supreme Court spent a lot of time talking about in the Osmond case about election purity and making sure it's a good system and not scaring off good candidates who don't want to play a game in the election system. That's what's happening here. I'm not attributing ill motives to Ms. Chowning. I'm just saying that what she did was illegal. She should not have been a candidate. And by being a candidate illegally, she harms legal candidates, people who play by the rules, and that should not be permitted. Thank you.
Thank you. You've got your rebuttal time.
Members of the court, Blake Matthews of the Nashville Bar on behalf of the Robertson County Election Commission. My co-counsel, Mr. Richard, is up in Springfield down in the back, and he sends his apologies for not being here today. There are some other notable folks who are not here today as a result of the action or inaction of the appellant. That would include the state election coordinator that we discussed or was discussed a few minutes ago, and then, of course, the candidate involved in this effort to remove her from the ballot, Ms. Chowning. The Election Commission does not represent the state election coordinator, and the Election Commission does not represent Ms. Chowning. Those interests are not before the court and not bound by the determination from this appeal. Mr. Roberts, in his remarks,
So let me follow up on who's not here.
right.
What authority then do we have to do whatever in this case, since we don't have all the players in front of us?
Your question screams of the Lynch family purpose case in terms of the public interest exception to the mootness doctrine, Judge. You could provide an advisory opinion, although the courts are not supposed to engage in that business, because the function of the Election Commission here is to administer the election. The function, notwithstanding what Mr. Roberts said, the function of the coordinator of elections it's a statutory position, specifically includes the duty to provide authoritative interpretation of the election laws for all persons administering them. That would be the Election Commission. That's precisely what happened here. So what the court could do if it chose to engage in an advisory commission context, and you see that in the Osmond case, you might say, well, we know that you're not bound, state coordinator of elections, but this is what we would prefer that you do in the future. That's the problem with the mootness doctrine insofar as cases like this are concerned. The body or person, but here the body, actively charged with the the interpretation of the law is not here. If Mr. Fuqua had chosen to bring suit against the state coordinator in a proper venue, seek a deck action in Davidson County, for example, you might have a pretty good argument, or at least one that's palpable, for issuing an opinion in conjunction with the issue that Mr. Robertson and his client have raised. But here, you just got an administrator. There's nothing to stop the coordinator of elections from continuing to provide the same clear interpretation of this law to every other election commission, including Robertson County in the future. So, you know, there's the hitch and the problem with the mootness doctrine, sort of in a nutshell.
Well, what about the candidate herself, or the official herself now?
Well, Judge, insofar as Ms. Chowning is concerned, as you know from reviewing the briefs, she was entitled to be in this case from the beginning. The writ statute requires it. Mr. Fuqua made an effort at the very end of the case, right before the final hearing, to involve her, I think to secure technical compliance with the statute, but she'd have no voice. And that's what the case law says. If you are a party affected and an active participant in the administrative decision that's the subject matter of the writ application, you're to be there and to have a voice, not just nominally, but to have a voice. Ms. Chowning, or the case insofar as Ms. Chowning is concerned, became moot on June 20. So before even the hearing that was conducted before Chancellor Oliver, because as of June 20, in its administration capacity, following its responsibilities under the statute, the Election Commission was required to tender final ballots and put them out for overseas voters. So Ms. Chowning wasn't a party as of June 20th, and there was not even an effort outstanding to join her as a party. That came later. So what Ms. Chowning's, again, I said, you know, Ms. Chowning's not here. I don't represent her. I don't know what she would say. I feel fairly certain that Ms. Chowning has her own unique perspective on steps taken, why she did what she did. That's lost to us. I know the Dean of Election Law, Ms. Kleinfelter, certainly doesn't want me arguing on behalf of the state election coordinator. That is a job that she aptly carries herself. So, you know, I'm here essentially carrying a sack full of people that are not parties. That's the problem with this appeal.
Which brings me back to my original question, is what relief could this court afford opposing party here? Other than, obviously, an advisory opinion, as you initially said. What is it that we can do based upon the players we have in front of us and the requests that have been made?
And that's largely where, or in part, where Chancellor Oliver was with this matter when it came for hearing. There is, the election cannot be unwound. We know that. Ms. Chowning cannot be told, well, I'm sorry, that election didn't occur, you didn't win. She is in the office. The election was conducted. It was conducted in accordance with the ballot preparation and submission guidelines of the state election coordinator, so there's no relief available to her. The Robertson County Election Commission is not in a position to unwind the clock either. The court could say, well, if this happens again, Robertson County Election Commission, the statute says X, but I think that's the only relief that you could apply as respects to the parties. But remember, the function of interpreting the election law falls by statute to the election coordinator. The election commission administers the election per that interpretation and per the guidance that the statute requires of that office. So there, you know, Judge, you know, the answer to your question is nothing other than an advisory opinion. And you see that at the tail end of the Osmond case. And there's an example of a case where somebody understood the exigencies of the circumstances, got the case before the appellate court, and what did the court say? Well, the only county before us is Davidson County. There are 2 other counties that are affected by this congressional district, and we hope that they will prepare and administer their election in accordance with this. But that decision was not binding on those counties. I think that was Robertson and Sumner, I believe. So it's dangerous territory to start plowing into. We kind of sort of hope you will do X, but that's where this court is left if it takes up Mr. Fuqua's appeal. Mr. Fuqua lost, the election's over, and it cannot be conducted again. I mean, that's clear under the law. I don't think Mr. Roberts would challenge that. As far as the interpretation of the statute itself, with all due respect, the election coordinator's interpretation is the correct one. The chancellor embraced it as being the correct one. The statute provides a process that does not begin and end with the submission of a nominating petition. Certainly, the first section of that elaborate piece of code says this is how you are to initiate the process. You file a nominating petition. The statute does not say, and the cases do not allow, that once you file a nominating petition, you're qualified. Think about the law if this court held in that regard. There are other threshold requirements. First of all, the Election Commission, in its administrative responsibility, has to determine whether the petition's even valid, whether it complies with the statute. Then there are some offices, the petition gets kicked because there are other requirements that accompany that petition. Sheriff is an example. There are also a host, I believe Mr. Roberts has been involved in some of these, of offices that have term limits that attach to them. Does that mean that a candidate for office can come in and say, well, no, I'm sorry, I've qualified, I'm entitled to be on this ballot because the moment I file a petition, I'm qualified? Election Commission might say, well, but there is this little matter of the term limit that attaches to your office, and you're a two-time matriculant through this office, and you can't. Oh, no. Per the Fuqua decision, you're qualified. There's nothing we can do about that. You're on the ballot. So the statute does not set up a beginning and end with the submission of the nominating petition. It is a threshold, and it's almost like a filing requirement in this court. You file your notice of appeal in 30 days, or you're out. But that doesn't mean you win your appeal just because you've complied with that deadline. There are other things that you must do. Here, the statute targets the filing deadline as sort of the disposition or determination point. After the filing deadline under the statute, then the determination of whether a candidate is qualified and entitled to access to the ballot occurs through the administrative process. The Election Commission will assess the adequacy of the nominating petition, assess whether or not the candidate has met other threshold requirements, whether there are fines outstanding that would preclude that candidate from running for the office, et cetera, and term limits. So what did we have here in this election as of the disposition time, the qualifying deadline? Ms. Chowning was not a candidate. That's undisputed. She had timely withdrawn her nominating petition. She had not qualified. We take exception to the argument that with the submission of it, she was automatically qualified like she pulled a ticket from a machine. No. As of the disposition time, she was not a candidate. She did not have a petition before the Election Commission. That's the thrust of the advice that the Election Commission received from the state election coordinator. That's the thrust of the decision that the chancellor made. She was not a candidate. She was not to be assessed. She did not qualify. There may be instances where the process moves forward to the point where someone has been determined to be qualified and is to be on the ballot and then withdraws, and this subdivision of the statute that Mr. Roberts and Mr. Fuqua rely upon would attach. But that is not the case here. That's not the advice that the Election Commission followed, and that's not the ruling of the chancellor. The argument that she unqualified, again, requires some notion or construct that she by herself could establish and maintain that she was qualified. Statute simply doesn't allow that. If you want to see a contrast, I mean, the legislature could say in subdivision F2, it's unlawful for a person to submit a nominating petition for a primary, then withdraw, and submit a nominating petition and thereafter qualify to run in the general election. If you want to see a contrast, look at F5. it specifically refers to a prohibition that the legislature has imposed on the submission of a qualifying petition, a nominating petition. That's not here. This statute does not say it is unlawful for a person to submit a nominating petition. It says it's unlawful for that person to qualify. And again, if you look at the entire statute, that determination only follows after the disposition time. That is the end time. And look at all the places in the statute where the specific time is preserved incarnate, specific times and days and times, so that candidates know that's the point in time where, that's the fulcrum point for a determination thereafter that you have qualified. So we have a filing deadline. We have a qualifying petition by Ms. Chowning that sits to run as an independent. We have a qualifying petition that sits for Mr. Fuqua to run in the primary, the Republican primary. That's what the Election Commission had, and that's the election that occurred. The mootness concept, back to the point, and I commend the Lynch Family Purpose Doctrine case. I think it's an excellent discussion of where this case fits and where it ought to be. Ms. Chowning was not joined as a party, members of the court, voluntarily. Mr. Fuqua knew that she was a participant, active participant in the March 8 hearing, the action which he's challenging from the March 8 hearing. He, in his briefs and his papers before the trial court, acknowledged that she was an active participant. The statute is clear. She's entitled to a voice. She had no voice. She was not joined timely. The chancellor correctly ruled right before the hearing, no, that's not appropriate to try to bring her now. And besides that, the statute's clear enough. I'm not going to rule in a manner that would impact her. So she's out. The timeline that we have in this case is strained not by virtue of dilatory action by the local courts. The Robertson County local rule that we've cited in our brief is clear. If you want to have a hearing in 5 days, you put a notice of hearing down. Mr. Fuqua just didn't do that.
Thank you. In your rebuttal time, counsel, appreciate you.
Your Honor, if I could address a couple of the statements were made, I would point out to the court that Ms. Chowning was served with the complaint. A motion to amend to bring her in was set, and that was denied. We were not allowed, but she was served. She would have had a voice had the court allowed us to do that, and that's part of the appeal. We didn't really sort of make that part of our original argument. The problem with Appellee's argument, and it sort of slipped in there very quickly, is that he talked about after the filing deadline. Well, after the filing, none of these things apply after the deadline is passed, or in this case. Ms. Chowning was qualified. The record shows that the Election Commission told her that her signatures have been verified. There was nothing left for her to do. She had done everything the statute requires, and so she was a qualified candidate at the time she withdrew. And that's in the record, the facts show that. So it was a little bit of a misstatement. The second is there may be other provisions in the statute that might disqualify a qualified candidate. And someone running for sheriff might have to have post-certification, or someone might have a residency requirement or something. We don't dispute that there are other disqualifying parts of the statute, and if you read the statute in whole, none of those are being argued today. What's being argued today is the legislature's clear statement that it is unlawful for Ms. Chowning to be a candidate.
So what is it that you think this court can do?
I think there's only one thing, asking this court to remand this case back, or to rule that she's an unlawful candidate. She's not.
And what does that mean? What is the effect of that?
Well,
Assuming
I
you're
think
correct in your analysis.
The only appropriate effect of that is that she would be removed from office, that she can't.
How can we do that?
Well, I think the court can say that she was never an appropriate candidate, that she was unlawfully a candidate, and therefore she's not fit to serve in that office. Whether that means a new election has to be held.
She's not before us.
Well, yeah, and part of that, Your Honor, I think is the appropriate remedy. Also, I think we're asking for a declaratory action as to the statute, as to the Election Commission violate my client's rights by allowing an illegal candidate into the election process. I think that's part of what is at stake here, is a clear statement.
As I understand it, the Election Commission is only applying the rules as interpreted by the state. Is that not correct?
Well, there's nothing in writing like that. I don't dispute that the Election Commission may have told the Robertson County Commission certain things, but
Well,
there are
you
no published
disputing
guidelines.
that actually transpired, that the Election Commission acted on the information or the guidance of the state in this matter?
Your Honor, I don't believe the record is clear how much they took that into consideration. What we know is that the Election Commission, the Robertson County Election Commission, refused to act and disqualify this candidate, and that's the issue that's before the court.
But she's now the elected official.
Well,
What
Your Honor, I
can
would
be
submit
done
that-
about that, assuming you're correct?
That she assumed the office improperly. I ran into this in a case in Murfreesboro where the sheriff had not had proper post-certification. And the question is whether he could actually win the election if he didn't qualify under the statute. Actually, the case didn't get litigated because he ended up losing the election. But we looked into that. We're dealing with something that the legislature has specifically prohibited. And I'm not sure I have the exact answer to it. I mean, it's part of bringing it before this court. But the legislature said it was unlawful. And so Ms. Chowling, maybe unintentionally, maybe intentionally, has done something that would make it illegal for her to be a candidate. It seemed that the only appropriate resolution would have to be that she's not qualified to hold this office. And how that plays out at the trial court level, I'm certain how this court's going to resolve that. I don't honestly know. But I do know she's an illegal candidate. Thank you.
Thank you. Counsel, we appreciate your argument, appreciate your briefs. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may be excused. May call the